These factors brought a new dimension to the case which entitled the respondent to be granted bail. That was the first misdirection, as it appears from our grounds of appeal, my lords. And secondly,
say for myself, I'm not speaking only for myself. There's obviously no difficulty with you referring to misdirections of the court. But just speaking for myself, I find it really inappropriate that both your argument and your
first point that I'm making.
Yes.
Yes.
No, I get your point, but I just don't want to be distracted by the outcry point that was made by the court of quo.
No,
that's not dispositive of this at all.
I accept that.
You accept that?
No, I accept unconditional. No, the point that I'm making is this. If we are going to be in the, let's call it the trigger jurisdictional facts of the but after the word.
These factors brought a new dimension to the case which entitled the respondent to be granted bail. That was the first misdirection, as it appears from our grounds of appeal, my lords. And secondly,
say for myself, I'm not speaking only for myself. There's obviously no difficulty with you referring to misdirections of the court. But just speaking for myself, I find it really inappropriate that both your argument and your petition refers to the judge in the court of quo of losing the plot.
Bail was denied. He came to court on new evidence. The court should have concentrated on the new evidence, not other issues or issues that have been ventilated already in the previous application.
that's what happened, my lords. And the court said it wanted to hear on those issues, my lord. And once the court has made that ruling, we are bound by the ruling, my lords. The court itself, court itself, acknowledged in its judgment that yes, this case has caused serious economic hazards to this country. It recognized that in its judgment. The court recognized that this case has caused a public outcry, and it acknowledged that accused person was facing, and today, my learned friend also acknowledges in his case of that yes, accused suffering serious charges, my lords. So it's not we're just throwing a hot air at the respondent. We are throwing facts. I was not supposed to do that, my lords.
Thank you. May I proceed?
My lords, we look at, if you look also, my lords, at the fact that the letters of allocation of fish quotas were not allocated to Namgoma Pescas Private Limited, Namibia. They were not. It was Namgoma Pescas SA, which already he agrees that it's not registered. There's no mention of Namgoma Limitada, nothing. It's Namgoma Pescas SA, but the agreement which he signed with Asia shows that he signed the agreement for Namgoma Pescas Private Limited, Namibia, which shows that they knew what they were doing. They knew the trick they were doing. All these other letters were just misrepresentations, my lords. They were misrepresentations.
Means, or the basis of our learned friend's argument means the appeal should fail. So that's why when I started the day, I said it's an easy appeal. Must be dismissed. The difficult question is, how do you interpret Section 61?
The fact that the state never proved or showed that the respondent didn't comply with his bail conditions.
My lords, the respondent is not naive. It's not naive, my lords. It's not naive. He can't at this stage attempt to run away. Not at all. He can't do that. He knows the state is appealing. He's still free on bail. He has to stay there. Why should he run away? Secondly, he's closely connected with these co-accused persons who are in custody. There is brothers and kin in the commission of this offense. If he runs away at this stage, he jeopardizes their chances of getting bail. He can't do that. He can't do that, my lords, and he is not naive. And as long as the matter is not yet gone to trial, the matter is not yet gone to trial, the matter is still pending in the High Court, he has no reason to run away now, my lords. You wait. My lords, we know, we have an example in this honorable court. We know of the matter of State versus Shaduka. He waited.
Which matter?
State versus Shaduka, my lords.